So if you want to sell or license internationally outside the boundaries of the United States, then you need international patent rights because the U.S. patent protects you. It gives you exclusive rights within the boundaries of the United States. So that will actually work if your customers are here in the United States, um, even if the thing is made overseas. If they're selling it to United States customers, then you can enforce your U.S. patent against them. And there's some other things. You need to have a U.S. nexus to enforce your U.S. patent. Um, but if you have markets, if you have customers, or your licensee, your potential licensee has customers in other countries, and don't forget about Canada. That's another country. Canada, Europe, UK. Colombia, Brazil, whatever. If you want to reach customers in those markets, or you want to license patent rights to someone who already has, distribution and manufacturing set up in those countries to reach those markets, then you need to make sure that you're preserving international patent rights so that you have something to license. If you do not have international patent rights, you've got nothing to license, and there goes that whole revenue stream. And if you want to sell direct to them because you have relationships in those countries, and you want to do e-commerce direct to those countries, you still probably are going to want to have international patent rights, rights in those countries, so that if there are copycats in those countries, you can actually go after them with a patent of that country. All right, so what's the most streamlined and efficient and cost-effective process to get international patent rights from a U.S. patent is the Patent Cooperation Treaty, otherwise known as the PCT. It's really, most of the countries that you can think of, that you've ever even heard of, are members of the PCT. It's a two-step process, and the first step is the one that you do when you file your non-provisional patent application, file your PCT application at the same time. Just plan on doing it at the same time. As far as cost, it's mostly a sort of paralegal and filing costs. It's mostly the filing costs, which are in Swiss francs, so they vary. And depending on the strength of the dollar against the Swiss franc, it can vary a lot. But it's usually just plan on between $3,000 and $5,000 for your PCT application. Maybe it comes in less than that. That would be great. And what they do is, it's a bit of a cumbersome application. We can file it at the USPTO because the USPTO is a receiving office for the treaty, which is a great advantage. So you can file it at the PCT. It's a cumbersome process, but you go through the whole thing, and then the system pulls all of the data from that application and from your U.S. filing and sends it to WIPO, World Intellectual Property Organization. And WIPO does, not immediately, but probably before the United States, does an international search. So they'll do a global prior art search based on your claims, just like what the examiner is going to do, except global. And at that point, they will issue an international search report, and you can respond or not respond. And it's a nice sort of early read on how the patent's looking, how the allowability is looking. And you can make, like I said, you can respond at that level or not. And then, then 18 months after your PCT filing, you will have to do the second phase. You don't have to wait till 18 months, by the way, so you can actually space it out, which is what we often will recommend people do. But 18 months is the deadline for national phase entry, which is you decide which countries you want to have patent rights in. And that's where the cost can mount up. So one of the advantages of spreading it out is it spreads out the cost. But you may not be sure where you want what countries are going to make the most sense for you. But in any case, I used to tell people to plan on $5,000 per country. Some countries are definitely going to be more than that, just because of the cost of their filing costs. Like Europe everything in Europe is expensive. So, so what we have at national phase, we have not just the foreign patent offices and their fees, but we also are dealing with foreign associates, foreign patent law firms, just like us, but in these different countries, and we have a network of them. And because they're the experts, once it enters national phase, it's sort of like you have your U.S. application, and then it gets a clone at the WIPO, and then in national phase it has babies, or it explodes, however you want to think of it, and then you have, let's say if you enter 10 different countries, you have 10 different patent applications that came from it. So we don't have to do anything. It's not like you're paying us to file each of these. This is why it's a streamlined process. It all kind of, the substance of it is there, but it has to be translated. It has to be, there are local, to that country rules about how things have to look to be filed and all that. And so that's why we work with the local law firms, because they're the experts on their country's rules. And at the end of the day, you'll get hopefully 10 patents, and they might all be slightly different depending on each of those countries and the individual trajectory and what those patent offices wanted, and any prior art that was in their offices, to the extent it didn't come up in the international search, which is less likely. That's less often a problem. There are some countries that will rubber stamp once Europe or the United States or a jurisdiction like that, highly respected jurisdiction, if they grant, like if you get your U.S. grant, that will often mean that there are countries that will just rubber stamp. They will grant because someone like U.S. or Europe granted. So you don't always have to fight at all of those different countries. But that's what that process looks like. So that's where the bigger cost is with the international protection. It's on that back end with the national phase. But you have some control over that. And, ultimately you can say, Canada is worth fighting for, but, Curacao, beautiful country, maybe not big enough to, if they're giving you a lot of trouble, not big enough to fight over. And you could just let that one go. In real life, probably Curacao is going to be one of those rubber stamp jurisdictions, and they may even share. So there are also some patent offices where small countries kind of band together and have a single patent office, and so you get a little bit more territory. So that was more than I wanted to say about that, but hopefully that was useful in terms of understanding and planning for international patent process and costs.